here. Welcome everyone to Shadowood. Thank you to everyone in attendance who has taken time out of his or her weekend to be present here today. Thank you also to Maggie Hurchalla, Jenny Sherlock, and our three panelists for lending their experience to our discussion today of the constitutional right of free speech. At a time in the history of our nation during which income inequality reaches historic levels, let us not neglect to observe that millions living daily with poverty or the imminent threat of poverty do not enjoy such privileges as we take for granted here this afternoon. Let us take this opportunity to advocate, instead of for our own interests, for the interests of the least of our community, those for whom there is little right to be heard. Let them say what they will. Thank you. Ladies and gentlemen, please welcome our special guest speaker, Maggie Hurchalla.
I want to thank all of you for coming out this afternoon. And I especially want to say that this is not, I know I have a lot of friends out there. This afternoon is not about me. It's not about cheering for Maggie and booing against the opposition. This is about the First Amendment. This is about the First Amendment of the Constitution of the United States of America. And I was thinking back to when was the first time I read the First Amendment? Not free speech. I'm the child of journalists. So, I know about free speech, I know about freedom of the press. But when did I first read that line? It was probably more than 65 years ago, about having citizens' right to petition government for the redress of grievances. It sounds terribly old-fashioned, but that is basically the basis of our democracy. And I find it awe-inspiring that our founding fathers, in a time when we had kings and czars and emperors, gave us the right to tell our government what we thought they were doing wrong and what they should do to make it right, to petition them for a redress of grievances. And so I am very proud to be here representing what I believe the First Amendment says. We certainly had some people who signed up who have agreed with the plaintiff in the case of Lake Point versus Maggie Hurchalla, and they may be able to ask some good questions here of looking at the First Amendment from a different point of view. But I am simply awed and happy to be representing a viewpoint that says we have the right, that it's our government, we are not their populace. I'm very proud to have you all here listening to people who know a whole lot about it. Thank you for coming.
Okay, I'm Jenny Sherlock. I'm going to be the moderator today. You don't need to know a whole lot about me because hopefully I'm not going to be talking that much, but I'm a lawyer. I represented Maggie in the case she's talking about with my partner Howard Himes, who's also here today. We have an appeal pending, and we are quite confident that the First Amendment will carry us through. Just as a minor point, I was also a newspaper reporter and editor for the Associated Press years ago, so I have a lot of First Amendment in my background. I want to introduce the panelists today. We have Martin Reeder, who is an attorney who has been a long time advocate for freedom of the press and represented the Palm Beach Post, among other news organizations, for many years. Richard Grosso, who is a professor at the Nova University Law School and has been a long-time environmental advocate in our judicial system. And Rick Ovalman from Carlton Fields in Miami, who is, I think, an undisputed expert on the First Amendment, has represented many media organizations, and is also lead appellate counsel for Maggie in her case.
Thank you.
So I'm gonna start and let the panelists just speak to you very briefly about their take on the First Amendment and why you should care, why it matters to you. We're lawyers. It matters to us, but why does it matter to you? That's right, it was only your questions. Thank you. Yeah, this is the questions that you all posed when you registered, so we'll get to those. But let's let each of the panelists just give you a brief explanation of why the heck we're here, why you care, why they care. I guess we'll start with Martin and go in order from my left to right.
Thank you, Jenny. Can everyone hear me? As Jenny said, I've been practicing law for a long time, getting close to 4 decades in Florida. The first 20 with a firm called Steele, Hector & Davis, a couple of years with another large firm called Greenberg Traurig, then 15 years with my wife in Jupiter. My wife's the lady with the black umbrella in the back row, Denise. And then the last couple of years with a West Palm Beach firm. So during that entire period, I have had the privilege of representing newspapers, magazines, book authors, others who are interested in protecting their First Amendment rights, who often fall under attack for their exercise of those rights. And you know, it's obviously important to me. I don't know if I could put into words why the First Amendment is important, but for me it's been important because it's been fun. It's been fun representing journalists and being at their side in the legal process, being their advocate, their champion, and that's just been a great pleasure for me. The other thing I want to say here is that unlike the other lawyers up on this platform, I'm not representing Maggie. I'm not involved in this case. I'm a little bit of an outsider compared to them. Richard is actually representing friends of the court, but they are aligned with Maggie's position, so he's not representing Maggie, but he's aligned. So that makes my perspective a little different. There's one other thing I want to say, because I've never actually met Maggie until today. She is legend. Before I ever moved to Martin County, I knew who Maggie Hurchalla was, and personally, I want to thank you, Maggie, because what brought me and my wife to Martin County was a patch of land, 20 acres, that just appeared to be beautiful to us. It's Florida pine flatwoods. It's only a few miles from here. Our opportunity to buy that land, to build our house there, and to make a life there is due, I believe, in large part to the fact that Maggie and other folks who were controlling the pace of development in Martin County decades ago made the decisions they made, and otherwise that land would not have been affordable or available, would have been paved over by now. We see bobcats on it, owls, deer. After a big hurricane, we even saw a 4-foot alligator one time. But it's very meaningful to me personally to be able to live on a piece of land like that that's still convenient to I-95, works with my work obligations and my wife's and all of our others. We didn't have to be way out in the back and beyond. And so anyway, we're personally grateful to you and to the other leaders of this county who made that kind of life possible here.
I'm going to stay. Hi, I'm Richard Grosso. I've been practicing law in South Florida for 30 years or so, and I have spent all of that time either representing people in court or representing them as they exercise their First Amendment rights to speak to their government agencies. I've had the pleasure of filing 2 friend of the court briefs in this case that speak to the larger issues, I think, that apply to all people who try to protect their communities and the natural resources in their state and in this country and on the earth that we all share. And I want to highlight the key points that are made to the court on those broader issues there. The first brief that I filed was on behalf of 2 doctors, Rock Pring and Penelope Canaan, who are the experts in the country on the concept of slap suits and how a variety of legal theories over the years have been used to inhibit people from bringing public statements against development, public policy issues for which certain people stand to gain, and they don't like it when others speak out against them. And let me start with this premise. As a lawyer who has, I think, been on my fair share of the opposite side of completely bogus legal or factual arguments, there is a reason why there are rules in place where people are not allowed to stand up and say things they absolutely know to be true that have nothing to do with trying to get government to do the right thing. There's a reason there are in place rules that say you cannot just bring a frivolous lawsuit that has no merit whatsoever, but you're trying to hold somebody up. You're trying to go after them in an illegitimate use of the legal process. That's not what this is about. The concept that I have seen happen a lot over my career is, I'm going to seek attorney's fees against you. I'm going to bring a lawsuit against you. It's the last time you will ever try something like this again for me or my project. And I want to make sure that other people who read about that don't have the temerity to try to stand up for their self either. That's what these professors have described as the history of what they've come to call strategic lawsuits against public participation. The concern with them, again, putting aside that small subset of times when, like, an economic competitor or somebody else will stand up and oppose a project or challenge it legally for all the wrong reasons without any legitimate basis. Put that aside. But when people bring to the attention of their government a set of facts, a set of policy considerations, that is pure First Amendment speech. And when people see, and it's particularly relevant during the times we are living in right now, that I am going to be harassed, I might be personally, financially liable, and even if I win, ultimately the stress, the difficulty, the lawyers I have to hire to defend myself, I'm just going to shut up and sit down and not be engaged. And the professors have shown with their research that is what happens. And in a country that is based on the democracy, that people are going to stand up and tell government, here's what we know for the benefit of your decision-making process, here's what we want you to do for the benefit of your decision-making process on behalf of us, that an inhibition of the most fundamental act of democracy is a terrible blight on our system of government in this country. That is what they have explained to the court. And that there ought to be an awfully high bar for somebody to be able to sue somebody else for having said things in the exercise of their First Amendment right, seeking to have their views known, their information known to government. The second, and you know that, and other experts will talk to you about your First Amendment rights. The other brief that we submitted, that I submitted on behalf of a number of environmental organizations, is directly relevant to people who are advocating on environmental issues. The idea that environmental conclusions, is that a wetland or not? Is it a high quality wetland? Is that a viable, important wildlife habitat? Is there a leakage underground that could cause whatever's going to happen there to get into my drinking water? The nature of scientific facts and conclusions, the courts have recognized for decades, are different than do you have a degree from that university or not. They're different from facts that are more readily, objectively determined. The inherent scientific nature, scientific debate, scientific uncertainty, it is inherent in science. There are no absolute truths in science. We're always learning more as the scientific process goes. And the courts have known that for decades. And the courts have acknowledged courts are a terrible place because they're not PhD panels to where to resolve questions about scientific debate and uncertainty. And courts have said, and we've explained this in our Friend of the Court brief, that when somebody asserts an environmental or a scientific fact or perspective or opinion, that's got to be protected. If there is any scientific basis for it whatsoever, the moment that I say that's a wetland, because there's at least one scientist that said it is, the moment I say that could pollute because there's some science that suggests you do that there, it's going to pollute. The moment there is any sound basis for a scientific conclusion, that should be the end of the discussion about whether I'm liable for having lied if a court of law or an agency ultimately says, no, I'm going to side with their expert and not yours. That is a huge aspect of environmental advocacy. Again, putting aside that I did no homework, I have no basis to know whether it's true or false, I'm just going to say it. You shouldn't do that. But in the uncertain, highly debatable realm of environmental policymaking, that is where I've never been, in 32 years as an environmental lawyer, I've never been involved in an issue where there weren't at least two opposing expert perspectives or competing reports on something. When I am advocating a position based on anything that's sound, the answer should be, that's totally protected First Amendment speech. So I'll leave you with my advice. Do your homework. Have some science that supports things that you say. Raise questions. You're always allowed to raise questions. Express opinions. You are always allowed to express opinions. Do not be intimidated. Do some homework. Speak freely. There's only one way to not get someone trying to chop off your head, and that's to keep your head in your shell like a turtle. That is not what it means to be an American citizen. Thank you.
Coalmine.
Hi, everybody. I'd like to take you back nearly 100 years to 1919. It's a case called Whitney against California. Anita Whitney was a reformer. She was a woman who was a suffragette. She found bail for the Wobblies. If you remember them, they were labor activists, sometimes violent. She worked in the hospitals. She was wealthy, but she spent her time helping the least fortunate people in society. Well, Anita, she gave money to the Wobblies and got prosecuted for it under the criminal syndicalist law in California. And that law said, even if you're nonviolent, even if you're a pacifist, even if you did nothing wrong, if you belong to an organization that engaged in violence someplace, or that advocated violence someplace, you were guilty too. She was prosecuted and she was convicted. And the case went to the U.S. Supreme Court. And it's become known because it has in it maybe the finest defense of the First Amendment ever penned by a Supreme Court justice. It's an opinion by Louis Brandeis, and I'd like you to listen to just a few words from it. He said, "Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that, in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness, and courage to be the secret of liberty. Courage to be the secret of liberty. They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is in inert people. That public discussion is a political duty, and that this should be a fundamental principle of the American government. They recognize the risk to which all humans, institutions are subject, but they knew that order cannot be secured merely through fear of punishment for its infraction. That is hazardous to discourage thought, hope, and imagination. That fear breeds repression, that repression breeds hate, that hate menaces stable government, and that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones. Believing in the power of reason as applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed." That was Louis Brandeis. And I would tell you that the key to his quotation is that the secret of liberty is courage. Now, Anita didn't do so. She ended up getting convicted, but because of the concurrence written by Brandeis, the governor eventually pardoned her. And then 50 years later, based expressly on that concurrence, the U.S. Supreme Court finally overruled Whitney versus California in the famous Brandenburg case. Now, why is this relevant today? It's relevant because now more than ever, liberty depends on courage. The courage of everybody at this assembly, the courage of people throughout the country, the courage of the people sitting in the U.S. Senate. It depends on the courage of people like Maggie and people like my client, Steve Hurwitz, who is in the sixth year of his litigation defending himself from a huge developer of the Watson Island project in Miami. We have anti-SLAPP suits, and they are fine. But what we need today more than anything else in this hearing is courage. Courage to stand up for our liberties.
Thank you. Now we are going to, we have a little bit of a foundation. We're going to take some of these questions that were submitted by some of you when you registered, and hopefully toward the end of the program we'll take some questions from the audience if you're coming up with questions as we move forward. This is, of course, about the First Amendment. There's some cards floating around that have the actual words to the First Amendment on them. There are essentially 5 areas of freedoms: freedom of speech, freedom of the press, freedom to practice religion, freedom of assembly, which we're having here, and finally, freedom to petition the government for redress of grievances. We're concentrating mostly on that last freedom to petition government for redress of grievances, which goes hand in hand with freedom of speech. And that's where most of these questions are directed. So we're going to start with a question from the registrants. I don't understand why the First Amendment protections of free speech, association, and the right to petition the government for redress are not an absolute defense against tortious interference, defamation, and other SLAPP-type actions. Can you explain why this is not the case? Martin, can we start with you on that question?
I'll try that one. There is a respected body of thought that folks are immune when they petition government for their grievances. For example, in the 1960s, the Supreme Court decided 2 cases. One of them has the word nor in it, and one has the word Pennington in it. And those cases stand for something that's become known as the Nor-Pennington Doctrine. And essentially what was happening in those cases was railroad companies were going before the government seeking the passage of laws that would effectively ruin the trucking industry. And normally the railroads wouldn't be allowed to get together and plot monopolistic behavior like that without running afoul of the antitrust laws. The case got to the U.S. Supreme Court, and the U.S. Supreme Court held that there was an immunity from the antitrust laws. That is, a total immunity, even if your motives were improper in trying to effect a legislative change. So that's an example where corporations have gotten the benefit of an immunity from antitrust law, and the doctrine's been expanded beyond antitrust law to include, from some courts, tortious interference. So, there is a respectable position that what Maggie did, she's immune from a tortious interference claim. It's not necessary for the Florida courts to find an absolute immunity for her to win her case. She's argued in the appellate court that Lake Point was required to prove actual malice, that is, that she told a knowing lie or acted in reckless disregard for the truth, and also that her sole motive was to cause injury to Lake Point. That is, not that her motive was to protect the environment, but that the jury was required to find that her sole motive was to cause injury. Now, there's lots of Florida precedents that those standards had to be met by Lake Point, and they weren't met in her case. So she doesn't need immunity to win, but there's a respectable argument out there that you should have immunity. If you go to your local county government meeting and you are opposed to something that they're trying to do and you state something that's false, you might do it unintentionally, because speech just isn't that precise. You know, where is the line between truth and falsehood? That was kind of Richard's point. A lot of times it's hard to tell the difference between what's true and what's not true. It's kind of a scale, you know, that's relative. But even if you show up there and you say something that you know is false, I'm not so sure that you shouldn't have immunity. And I would defend that position on behalf of a client. Not everybody agrees with that, but I could defend it.